part-time, stay in private practice, and work as a magistrate part-time. I did that for 2 years, and then after that, I'm now the court administrator and the magistrate. I'm full-time out of the township as the court administrator and magistrate there.
How is it different than being a judge?
Well, there's a couple of different things to that. First of all, judges make way more money than I do. But the statutory difference, we're defined by statute, so we have limited authority. We only can do what the statutes say we can do. It boils down basically to we can't really make any determinations of law in areas outside of small claims. We're authorized, attorney magistrates are authorized to make determinations of law and make findings for small claims cases. But anything else, we do more administrative or ministerial duties. So we do the arraignments. We do first appearance on a criminal case, will come before a magistrate, where you inform the person of what their charge is, their constitutional rights are presented to them at that point in time. If they need an attorney appointed, we'll take care of that for them and set their next court date and set bond for them. We can handle all traffic matters, civil infraction traffic matters, speeding tickets, stop signs, things like that. We'll deal with those. We also do small claims. We're authorized to do marriages in the state of Michigan, so I do all of those for our court as well. So basically, we do search warrants. We do arraignments on the weekends. So as you're hearing these things, you're hearing all the things the judges don't want to do. That's what we end up doing.
That's a lot of paperwork.
But yeah, so we end up taking care of the sort of the pre-trial things, the things that go on prior to trial, prior to decisions being made. The judges then will hear facts, apply those to law, and make determinations as to guilt or innocence in a criminal case or as the outcome of the civil case. Yes?
Do you have to work in a courtroom or can you work out in a regular office?
So throughout the state of Michigan, I suspect this is probably the case across the country. Every court sort of does things differently. When I go to conferences, I'll talk to people who are magistrates in other parts of the state, and it varies greatly. I have a courtroom. I have a bailiff. I wear a robe when I go to the courtroom and do all those things. Some of my colleagues, say in the northern part of the state, for example, work out of their office. Somebody comes in with a speeding ticket, the state trooper, and the person comes in, they sit at a desk and they work it all out there. But it kind of varies from court to court.
Yeah, when you actually do wind up hearing a small claims case, which means we have not been successful, typically how long do they last? What can a person expect if they have fought their way through the mediation and not caved in?
Sure. So it varies. I mean, it depends on how many issues there are brought before the. But I mean, I'd say the average hearing on a small claims case maybe half an hour.
Okay. That's pretty easy, actually.
Yeah. So I mean, and I'll have 4 or 5 of them stacked up amongst a bunch of other things too. So I'm trying to work them to stay focused on the issues and hear what I need to hear. A lot of stuff is similar. I mean, some of it's by statute. So for example, if there's a dispute about security deposit on landlord-tenant cases, I mean, we have a statute that drives how that's going to be sorted out. So I'm going to start asking questions pretty quickly in as to were these points taken care of as long as it went through. So I'm kind of trying to drive where we get to the point on facts and things like that. I'd say on average about half an hour to get it started.
That's impressive.
Do you ever find that you run into a question of law that you aren't authorized to make a decision on? You have to defer it to the district court, or?
Well, it's small claims. I mean, as long as it's as long as they're not asking for something that's not. I mean, basically, now, if there's money damage that we can distill it down to, then we can take care of it. But if there's an intentional tort or things like that, so people come and ask for pain and suffering. That's something that's outside of our purview. It's outside of the purview of the district court, really. So I'll tell them, well, I mean, I can't deal with that. But we'll try to get it down to things that they can deal with, or I give them the option. If you want to pursue those claims, then we'll have to dismiss this case and you have to file it elsewhere. Yes.
Do you ever come up with creative solutions, or is it go one way or the other, one side or the other?
I mean, it's the creativity comes down to you guys. I mean, where you can sort of get resolutions where there's some give and take and things like that. I mean, it's sort of when it comes to me, it's all or nothing. Your claim's either proven or not proven. And there may be counterclaims, there may be offsets in the claim, so I mean, they may be asking for, $2,000, and the other party may have some offsets to that claim, so we get down to, distill it down to a number of $1,800 or something like that. And the other thing we can do then is, if the parties are amenable to it, we can set payment plans and things like that, but we don't have a lot of flexibility. I mean, I can't order a piece of property to be returned to somebody. I can say, that piece of property is worth $500, you got to give me $500, but I can't order the delivery of property from one person to another. Yeah.
Well, I assume you listen to the plaintiff and then you listen to the defendant and come up with your decision. Do you need to, in your role, if you find in the case of the plaintiff, for instance, you award them what they've asked for in their complaint?
You award them what they've proven. So they may ask, sometimes, and I'm sure you guys have seen this too when you're mediating, the claims is 55. The claim limit in small claims is 5,500. So some people just write 5,500 down there because that's what the form says we can fill out and do, right? So once we start taking testimony out, we may find that what they're entitled to is $1,000, not the 5,500 they're asking for. And there's things people ask for. Well, I had to take the day off of work. Well, that's not a part of what we can give you an award for in a small claims case. I drove here, drove there. That's not really part of the deal. So it's all what they've proven in their case. So I mean, they may have part of their claim they're just unable to prove or meet the burden of proof on. So that wouldn't be awarded to them. But what they could prove and what was allowable, that would be awarded.
Do you follow rules of evidence during the hearing?
No. It's sort of a bit of a free-for-all. They follow the rules of us sitting up front. So, we set some ground rules. I mean, right off the bat, what I'll tell everybody when they come in is, the first thing they get is they get a waiver of rights. So, I mean, you don't have to be proceeding small claims. The plaintiff files there. The defendant doesn't have to be bound by small claims. They can ask to have the matter removed to the General Civil Division. By going through small claims, you can only sue or be sued for the $5,500. You can't have an attorney with you. You don't get a jury trial, and there's only one appeal available from the magistrate's decision. So if they're not comfortable with those things, they want to get the advice of an attorney is usually what the deciding factor is. Then they can say when they show up at the hearing, I don't want to proceed today. I'm going to file a removal, and that would go to the General Civil Division. After we get that, the consent, and we do that in writing, they sign off on that, so we don't have any dispute later that they didn't know. Once they've done that, then I sort of set some ground rules. I don't want any people interrupting each other. I don't want questions being asked directly to each other. They ask questions to me. If it's something that needs to be answered, I will take care of that. And I'm just going to proceed. Yes?
So when they appeal a magistrate's decision, does it then automatically go to a court and a judge?
It will go to the district court judge.
District court judge?
Yep. And then with small claims, that's the only appeal you have available to you. So if you had a case that started with the district court judge, you could appeal theoretically to the Supreme Court of the state of Michigan if you wanted to. But once you start small claims, you only have 2 shots at it. Yeah.
I was in court one time with a person who'd done mediation, and he was absolutely convinced he was right, and the mediators weren't able to budge him on trying to negotiate or anything like that. And the magistrate, who no longer is on the bench, by the way, long ago left, decided for the other party. And he said, is there an appeal? And she said, I told you the case is over. And he said, is there an appeal? And she said, would you like to leave now, or would you like to be escorted out? But that was really kind of interesting. He should have paid more attention in mediation.
So in mediation, we get like people come in with like 400 photographs of their car or the damage to their apartment or whatever. Is that all things that they bring to you that you need to look at, or?
They bring it. Do I need to look at it? No.
Yeah, that's what I was wondering.
The problem with photographs is, of course, the people will take say the space that's at issue is this big.
Right.
They'll take a picture of this.
Yeah, that's right.
And so you have no way of knowing what the rest of the photo is, what the rest of the picture shows.
Yeah, they take it out of context.
Yeah, exactly what they want to take a picture of what they want to show. And sometimes the pictures we see, I'm sure you guys see them as well. I mean, I look at it, I have no idea what this is.
You don't know what it is.
Let alone if it helps me out at all. So I mean, I'll look at a few pictures from time to time, especially if they're if they're wide angle, taking a picture of an entire room, for example,
Right.
giving an idea of context and what's going on with it, that certainly is helpful. But when they start taking pictures of, this piece of a
Yeah,
table
piece
that
of
has a
tile or
scratch on it, that
something,
big, that's not very helpful. The other thing that we have is people come in, I got it on my phone.
Yes, right.
I'm not dealing with that at all. If they don't go and print things out, then I'm not going to see what's on their phone.
How about a lease? We look at leases.
Oh, absolutely. Yeah, leases are very important. Leases, I tell people all the time that, the reason we write things down in a form of contract is because the answers are there, right? I mean, you enter into a lease or enter into any other contract, and you know everything's going to work out. What could possibly go wrong, right? If you've entered this agreement, you're just going to pay rent, you're just going to live there, and everything's going to be fine. But when things do go wrong, the lease is there to answer all the questions for us. So absolutely, when there's any writing that we can fall back to, and the terms are there, they'll tell you, well, I mean, that says that in the lease, but we agreed otherwise. Well, it says here at the very end of the lease, if you want to change anything, you have to put it in writing. Where's that writing that changes that? So that's why we want to make sure if there's any paperwork to read and anything like that, it's often very helpful. Yes?
Related to that, if there is nothing in writing, like for a landlord-tenant or a personal loan, and there's a difference of opinion or a difference of memory of what was agreed to, what do you do to...
You look for points that people do agree on. You start with where, and if the only facts you can get people to agree on is that, they understand each other's names and that's it, that's all you have. But I mean, often you can, start getting into it and figuring out, okay, well, this happened on this day, right? We agree on that point. And then start building where points of agreement, and oftentimes there might be some sort of objective facts that are available to you that can give you some more information or give you a better idea of what's going on. But I've had situations where people are so far apart from each other that, one or both of them not telling me the truth, the whole truth, or partial truth, whatever the case may be. So then you have to fall back to who has the burden of proof. And the plaintiff has the burden of proof to prove their case. If I'm not satisfied that they've brought me enough, objective information to give me something to base a decision on, then they've not met their burden of proof, and I'm going to have to rule against them.
Oh, me?
Yeah.
Yeah.
A second, yeah.
Yeah, I think you pretty much answered my question. It had to do with what kind of standard of proof do you have? If the oil cap comes off a car, is the last oil change guy the guy you go after? Or if there's bed bugs after a tenant moves out, who is responsible for the cleanup?
Yeah, so the car cases are interesting because, if the oil cap comes off the car, did it happen, the day after, or did you drive it for 2,000 miles and then, then the car is
Say that's the case.
So you have to have some, reasonable temporal connection to the event, to the end, and to the damage. I mean, I'll people come in frequently in car cases, and I'm sure you folks see this as well in your mediations. Somebody will go out and buy a part to a car somewhere else. They'll go to a junkyard, buy the car, and then they'll find a guy that's going to put the part in. And, then the part gets put in, and it turns out later on that the part was the wrong part. Was the guy that put the part in responsible for it? Is the person that bought the part responsible for it? Is the person that sold the part to him responsible for it? Where do these things all come together? And now you've got sort of a collaboration amongst 2 or 3 people. Where do you lay the fault on that? And then to add more interest to it, they usually find the problem 2,000 miles down the road, and who knows what happened in the intervening period of time.
Sorry to harp on this, but to get back to a landlord situation with a lease, if you find a term written into a lease that is illegal because it's just putting a responsibility on the tenant that the landlord should always have, that's a question of law again. Do you rule on things like that?
Oh, absolutely. Yeah.
Okay.
Yeah.
How about a dog injured by an at-home groomer, which results in about $10,000+ bills? Who's responsible?
Well, that's outside of the small claims purview.
It is. That's a civil court matter.
Yeah. So, but without more facts and testimony on it, I can't say that there's a cause of action there or not. I mean,
And there's no law that
does the groomer have insurance? I mean, are they regulated in some other way? I mean,
they're not.
There's a number of factors that would come into play there.
I'm a member of the Michigan Association of Justice, and this value of a dog comes up often on the listserv, and basically, it's the replacement value of the dog always is the maximum you could ever get. So, if it's a mixed breed, pretty much nothing.
Regardless of veterinary bills,
Correct, yeah.
Really? So unlike mediation, do you allow witnesses?
Oh, sure.
You got it.
Yeah, so, right, when people come in, especially if I see they're sitting with 4 or 5 other people, they'll come up themselves and say, do you have any witnesses? They'll bring them up and we'll swear everybody at the same time, put them all under oath, and then hear from them. So one of the issues we have with witnesses is they're often just redundant of what the person's saying as well. So I mean, you hear this, so that comes out to sort of case management, corporate management. Okay, I appreciate what you have to say, but you're telling me the same thing over and over again. Do you have anything additional to add? Or when I ask people to sum up where they are, where we got to, I say, okay, well, I've heard this, and this, and here's the points that I understand. Is there anything the court's not heard at this point in time? And give the parties an opportunity to go back and get new information. Oftentimes they hear, tell me the whole thing all over again. So we have to kind of get that folks back again. Yes?
Back to landlord-tenant again.
Yep.
Is there Michigan law, or local law for that matter, I don't know, that if there has not been a written contract, a landlord contract, that the case that you can look to make a decision? I've had cases in which there haven't been written contracts, but one or the other party harkens back to some other law that says, if you do thus and so, give this much notice. Does such a thing exist, or are these?
Well, there's a whole section on landlord-tenant law, and so there are notice provisions. I mean, as far as what notice you have to provide, especially with return of security deposits. I think it's very specific about when you move out, you have to provide a forwarding address, and then landlord has so many days to respond or send off claim of damage to you, and there's a back and forth story goes back there. So there's a statute that backstops everything in landlord-tenant cases. If there's not a lease or if there's illegal terms.
Okay, so they can refer to another law.
Yeah. Now, obviously, we're not asking the mediators to sort of
right.
the law out.
We don't.
Yeah, right.
Tell them that's interesting, but let's see what we can agree to here.
So in the process of hearing a case and all the evidence, sometimes peripheral things come up, maybe other illegal activities and things. What happens in that case in your court? Do you just deal with the case at hand and not deal with maybe some other illegal activities that are, maybe, I won't say domestic violence or threats, or maybe there might be drugs, some other illegal activity? Because we're compelled to do something about it if we discover.
They're probably less willing to talk about those things when they actually walk into the courtroom.
Yeah.
I don't really see or hear anything like that.
Okay.
Magistrate Fink.
Yay. Welcome. We're delighted you're here.
Thank you. I just finished my docket and I sprinted across the parking lot.
Okay. So right now what we're doing, while we wait for you and Magistrate Garwood to come, is we were just asking questions and answers. So, okay.
So the first question I got was, what was my background and how did I get to this point? So we'll ask you.
Okay. I have a bachelor's degree in social work from Eastern Michigan University at a date in the fairly distant past. And then I worked in foster care and adoption in Detroit for about 5 years, and then went to law school. And when I finished law school, I've always worked in private practice with various family members. And when there was a change made in 14A used to have 2 full-time magistrates, and I always had. And there was a determination for, I don't know why, that 1.5 was plenty. The 1.5, me and the other magistrate do not think that's enough, but that's not our decision. So when they changed to 1.5, they asked me if I would do the half-time job, And after a couple of years, it became full-time.
Are you still 1.5?
We're still 1.5.
They switched.
It's
The
not
one-
enough.
The one became a half.
Yeah, the full-time magistrate became the half, and I became the full-time. It's not enough. We need about 1 2/3. So.
Do you get paid a half?
He gets paid a half, yeah. No, he doesn't get paid half when I do. He gets paid an hourly rate, depending on when he works. But I don't know how Mark does it with just Mark, but if I do, part of my job is that I do the jail arraignments every afternoon. So everybody that's in the jail, so I do the felony arraignments for people who've been picked up on felony warrants or bench warrants for not appearing. So that's something that I do that Magistrate Nelson and Magistrate Garwood do not do. They don't do it. You do some of that, right, for your own things, but mostly I do that. Yeah. So if I'm not there to do that and the half magistrate is not available, we have a problem. So that's why I'd like it to be 1 2/3. So there's or 1 2/2 would be okay too. We need a little something else.
So, just clarity. Each now judge has so many magistrates?
No, each district court has 1 magistrate. Except for 14A, we have 1.5.
And that's Washtenaw County.
Right.
Other courts in parts of the state have more or fewer. Some
Right.
Some don't have any. Most have at least 1. But
All right. And these jobs are not selected, you just apply and depends on you?
Yes, that you serve at the will of the chief judge. So the chief judge of each district makes the hiring and firing
And
decision.
firing, okay.
Yes.
All right.
that's a statute. We can be fired by statute. It says we serve. The statute actually says we serve at the pleasure of the chief judge. I don't know, what that means exactly. some
That
days,
sounds dirty, doesn't it? Yeah.
some days it feels precarious.
Yeah. Yes.
If you had to, and however many judges you would prefer, what would be addressed that you feel isn't being addressed now?
Well, the biggest problem is just coverage because Tom only works part-time. He has a regular Friday docket. He's in Chelsea every Friday morning, and 2 Fridays a month I have a docket someplace else. So if I'm sick on a Friday that I have a docket, or he's sick on a Friday that I have a docket, it is a scramble. And there have been days when I've gone to 3 courts in the county in one day, which is just a nightmare. I'm in Chelsea and then in Saline and then back here for jail because he's sick. So that's what we're missing is when both of us need to be someplace and we can't, then there's a problem. It's probably true we don't need 2 full-time people, but the way we have it right now is just...
You need some backup.
Yeah, we need some backup.
Hi there.
Hi.
So I met you after you became a lawyer and before you became a magistrate. And I have it in my mind, and you can correct me if I'm wrong, that you've had some training or some experience in mediation yourself. Is that not correct?
Yes, I have. I did my private practice was primarily family law. So I mediated cases for other people, and I was involved in mediation as a lawyer. And then I also did some civil litigation, so I used the dispute resolution center for lots of things. Yes.
When I was in private practice, I did a lot of probate practice, and I would utilize the dispute resolution center quite frequently for the probate side of my practice as well.
So I had asked you each to talk about what you did as a magistrate, and you pretty much covered, haven't you? Pretty much what you do as a magistrate?
For last Thursday, sure. It changes. I mean, it's a lot of it's fluid, and things change. I mean, it's never the same job 2 days in a row. It's pretty interesting in that respect. While we do a lot of traffic things, so a lot of people get their license suspended, but how they got to that point always changes, and where we go from there kind of changes from time to time as well. So it does vary quite a bit.
How much of your jobs are administrative, and you're not actually hearing and deciding cases?
So I'm unique from Elisha. I'm the court administrator, so I do all of the business of our court on top of my courtroom duties. So I'm split. I spend about half the time in the courtroom, half the time in my office, dealing with the business side of the court. So I deal with personnel issues, all the things that are involved in running a business, our accounting and our budgeting and all the things that are of that nature. So I'm sort of split.
And you've got a lot of employees. Do you supervise them directly, or?
Fortunately, I don't have to be too directly involved in them, but I am their direct supervisor. I mean, they're for me, knock on whatever that is, they're all very self-sufficient and work well as a team.
We're delighted to have our third magistrate here, Magistrate Garwood.
Here, my apologies, the docket ran long.
Yep, I just got it too.
So, Magistrate Nelson has been holding the fort for quite a while.
He did that last week when we had lunch. He had lunch by himself until we could get there.
Sally?
Yes.
Could magistrates introduce themselves again for those of us who came in late?
Certainly.
And
Actually,
The whole introduction?
the whole introduction, yes. So this is Magistrate Mark Nelson,
thank you.
Magistrate Tamara Garwood, and Magistrate Elisha Fink.
Thank you.
And Magistrate Nelson is with 14B.
It's my jurisdiction is Ypsilanti Township exclusively. So B is in 4.
I'm the 15th District Court, so the city of Ann Arbor.
And I'm 14A, which is the rest of the county.
And then we also work together as a team on a rotation for weekend matters.
Thank you.
So I mentioned earlier, arraignments, which are the first appearance on a criminal matter. Arraignments happen in Washtenaw County every day of the year. So we handle weekends and holidays. We're over here doing arraignments for a few hours a day.
And that's it, you're the only 3 magistrates in all of Washtenaw County?
Well, then there's a part-time person for 14A.
14A.
And he,
The half.
yes, he was the first magistrate in the county starting in 1986, and he just retired in 2014. So he works 1 day a week, and whenever I can't make it.
And it should be mentioned that Magistrate Garwood was also a very, very excellent mediator in family law.
That's right, and worked for the DRC when I first
I did.
She was one of our small claims mediators.
That's right. And now actually we've started a pilot program in the civil division where we're doing mediation on general civil cases too. But I'm acting as the mediator, sorry. I'm acting as the mediator for that. So.
When cases come to you, do you know if they've been to mediation?
Yes, I do.
Yeah,
I do too.
Yeah, part of your paperwork is in our file. So the part where it says the matter has not been resolved, that's in our file. So the ones that skip over mediation come to us, for my court anyway, are primarily mini tort cases, but it's also statutorily driven. We filter those. Those don't come to you, but the vast majority will go through the mediators.
And so the mini tort cases are the ones that we used to do before, if I remember correctly. And that's car accidents, is that right?
We made the decision to stop doing that because they were matters of law.
The court asked us not to stop doing that.
There's a statutory cap on the amount you can collect on a mini tort case.
That was a great relief, by the way, because people were all over the place on that stuff.
So that was helpful. And is it true now that we don't get them from any of your courts?
Correct.
Every once in a while, one sneaks through, which we don't refuse them if they come.
Well, it's worth a shot.
But you could refuse them, I think. You could say, we don't do this, this was a mistake.
In general, do you see that it's been helpful that they've been to mediation? I mean, they come to you with more amenable to
whatever your decision is.
We're not really permitted to discuss with them what happens in mediation. So I don't ever get a read about whether that, I mean, if they've come to me, they weren't able to solve it. So I assume then that mediation was not helpful to them. Or they would have worked something out after mediation before they get to court. But since we're not talking about it, I really don't ever have any idea how it went, other than they didn't resolve it.
We'll have to have people say, well, in mediation, this happens. Stop, hang on a second. Mediation's like Las Vegas. What happened there stays there.
You're half a mediator. You're half a mediator. Used to say if they come to him before mediation, they're this far apart. If they come after mediation, they're this far apart.
Yeah, well, Tom, that's probably true. Tom said that, like I said, in it forever, so.
Yeah. Okay, and he knew it before there was
Yeah.
mediation.
Yes, right.
Right.
The question in the corner?
You answered it just now.
Okay, okay, yeah.
I'd like to understand the sequence of cases. Are cases filed and then is it ordered to mediation, or do they all go to mediation, or what happens? And then if somebody, the second part of that is if a court is reaching mediation, do you ever see it?
Probably part of that we all do differently. In our court, when a case is initially filed, so a person walks in, they file an affidavit and claim, and then they are automatically sent a notice that their first court appearance will be mediation. And I think they're given a one-page sheet about what mediation is, as I recall, and what to expect and what to bring.
It's bright blue, so it's
That's right,
supposed to look different, and they're supposed to read it.
Right. For whatever that's worth. And that goes to both parties. So they both get this notice saying, you're going to small claims mediation. And then they're both ordered to appear. Now, in our case, our own court, it's very common that people will send a letter, or they'll come in and say, I hate this person. I can't be expected to go to mediation. Or this person's not going to show, or this person's very unreasonable, and so this will be a waste of your time. All sorts of things come in. Or there's a personal protection order between us. We can't be in the same room. And then those requests come to me. I don't know if they do that the same way with you guys. And then I have to issue a written opinion whether they'll be required to go to mediation or not. Or we've already been to private mediate, because we have, in Ann Arbor, we have a lot of students. And so the University of Michigan offers them mediation services as well if they have a dispute. So they've a lot of times already been through mediation. And then a decision is made, whether they'll proceed or they won't proceed. And sometimes a decision is made and we set up special protocol where they're in 2 separate rooms, or a variety of different things. Or somebody doesn't want to come because they live out of state, we'll let them appear by phone. A variety of different circumstances happen for us. Do you have different happenings?
No, that's pretty much the way we do it. And then I think the second part of your question is then what do we see after mediation? So we get the form that you filled out where it says whether they've agreed or whether they're requesting a trial.
You probably haven't seen that form.
No. Okay.
Just Miles and I have.
Okay, so that form,
after you mediate.
it's really just a checklist where it's marked what happened in mediation.
It's called a status report.
Yes, and then that comes in the file so that I know whether they've gone to mediation and what happened. Sometimes what works out at mediation is a consent judgment. So then, of course, we have to sign those in order to make them an official judgment. So we'll see that too. And then if nobody shows up, that's on the stand list also. So we then dismiss or default, depending on who came or who didn't come.
And post-judgment, we'll see things, and what will happen is if an agreement is reached and that agreement is then violated as well, that comes back as right now, it comes back as a new case. It's a breach of that contract. We've been discussing how we might be able to fix that a little bit, because it sort of lacks some efficiency and it makes parties start over, especially the party that won. But right now, it would be a breach of that other contract if there's not a judgment in place. They reduce everything to a judgment, that judgment can be enforced. But oftentimes people don't want to have a judgment because that has an effect on credit rating and things like that. So they'll mediate to not have a judgment. So we've been sort of kicking around how we make to streamline that.
I'm delighted you're kicking that around. That would be really helpful. I don't know, the mediators don't usually deal with that because we always say call the DRC if you have to. They'll sometimes say, well, I was in mediation with Nancy Soderholm, I want her phone number. And I'll say, you are not going to get her phone number, you're going to talk to Miles or me.
And then what happens?
So that would really help us a lot if we were able to have a breach of contract go directly to you all after that. Occasionally, we'll be ordered to remediate it, and I don't think that's particularly helpful if it hadn't worked the first time.
Well, that's a good point, and we have also talked about that if we are going to require a new case, there ought to be a way to signal
yes,
that this is just to enforce their mediated agreement.
Right.
Yeah.
Which is what we try to do. If they come back and refile, we try to get them back on graded
right.
on my docket.
Right.
But you have a lot of clerks to deal with, and so they
And I do two, I have 2 courts.
And you have 2 courts,
So, yeah.
each with their own set of clerks.
Right.
So that is the place to catch it, but it might not be caught. Yeah. Okay, well, thank
And
you
also,
very
because
much.
when people are filing their paperwork, they don't always know that that's what they're doing.
That's right.
Right. So if they don't say, we had a mediated agreement.
And
that's
here's
been
the
breached,"
agreement, and here's the,
Yeah,
here's
and
the-
then I might not even see the previous file, and, yeah, so that's a customer issue as well as a court issue.
There are some cases where 2 people come together in mediation in good faith and they just can't come to an agreement. They each move a little bit, but they can't get close enough together to agree. And there are others where people are completely in bad faith. They have no intention of ever settling or budging. Do you get any indication of that in the reports you get?
No.
No, it tells us who was there.
And
That's
whether
all
it
it
got
does.
resolved.
Whether they
Resolved.
resolve it. Okay.
But it takes about 2 seconds of curiosity to know those answers. So, just like as a mediator, when everybody walks in, it takes you probably 1 second to know who's there in good faith and who's not.
So we thought we would like to show you, since you've been talking about what you do, to show you what we do in mediation. And so we have 4 actors who are going to act. Okay. Good. So we have 1 minute. Any last questions?
Nobody's got a question?
Well, I think this case pointed out one of the difficulties of mediation, that is, sometimes it drags and drags and drags.
Right.
And in the courtroom, you can move it on, but in mediation,
That's right.
In the courtroom, as soon as she admitted she owed the money, we're done.
It's over.
I mean, that's it. I mean, I'm starting to write a judgment
Yeah.
at that point in time, and when we're sending them on their way.
Yeah.
Because, I mean, there's no dispute as to the facts, and, you know, they have an allegation of a death, an admission of the death. There's nothing else to talk about in the courtroom. So that's where mediation becomes, you know, important to the parties. And then, you know, when we're going back to the township board and funding this project, you know, we always tell them this is a matter of public service. This doesn't, I mean, it benefits the court somewhat, you know, and then I don't see all of the cases come through to us, but, you know, I'm capable and willing to do that. The benefit is to the public, the parties that are able to work out an agreement through this, and all these other issues can be dealt with. Yes.
So you would never set up a payment plan?
Oh, if people want to do a payment plan, I can become part of the judgment, yes.
Okay.
Yeah, I mean,
All right.
that
But they
can,
both have to agree right there in front of you.
yeah.
And does the party that needs the payment plan, the defendant, bring it up? I mean, do you hear that regularly from people? I can't pay you all today?
It happens. I mean, people, or if they're aware enough to make the request, yeah. But I mean, I can't step in and make a suggestion that's
don't,
beneficial
okay.
one party over the other party.
Okay.
You know, we have to just, you know.
We're going to enter a judgment that says it's payable in full. And then the second paragraph in the judgment says, if it's not paid within 30 days, and there's no installment payment, then the other person can take action to further collect. So the other thing that many people will say once I make that judgment, all right, you owe this and it's due in full now, and they'll be entitled to take collection actions within 30 days, people will suddenly then propose a payment plan. And so then we'll spend some time working out a payment plan if both sides agree. Or someone will say, well, look, this is what I can do. I have, you know, $800 in my pocket today. I'll pay you $800 today if you'll let the rest go. And then sometimes we're able to work that deal out too at the last minute. It's surprising how much money people who can't pay anything will bring to court. So they have to pay a few dollars less on the back end.
So you're saying they'd be willing to pay most of it up front, and then the plaintiff is willing to just settle for that?
Cash is king.
That's
Right. Okay.
I mean, if you're going to wait for 10 months to be paid in full, maybe if you offer $800, I mean, obviously you don't have that money, but for a lot of people that works, and you'd rather just have the money than deal with, oh my God, what if she doesn't pay, and then I have to go through collection and all those things. So.
Do you have any idea of how often a consent judgment results in full payment?
No idea. I mean, the only ones we know are the ones that, you know, come back to us. But so I have no idea if people give up and just I've had it. This is they write it off in their mind, or if they, you know, if they collect on it. I have no idea.
I love what you said about going to that place of finding out if the person admits that they owe this money and dealing with it then, instead of having to go through a song and a dance with everybody. It's like, okay, well, let's figure out then how we can resolve this and get this done.
Yeah. So, I mean, right. Once we have that hurdle of matter of law,
Yeah.
satisfied, then yeah.
Because a lot of people like to go off down a whole lot of roads and a whole lot of tangents, and it's just like you got to reel them back in and say, well, this is what we're here to do. And,
So at the beginning, I always tell people, I have one, maybe two sentences of why you're here, and I know, as a former lawyer, as a human being, as a mediator, that you're not here because of this one sentence.
Right.
You're here because of a whole lot of other things. I can only deal with the one sentence. So I'm going to redirect you. I may interrupt you while you're talking to try to get you back to the legal reason you're here, because I can't solve the other reasons. And
good point.
maybe solving the legal will solve the other reasons, which is sort of what you guys ultimately said.
Well, I was just going to say that it is more than just the legal thing, especially if you're neighbors. So you're trying to mend the relationship too.
Right.
Sometimes maybe it doesn't matter, but sometimes it does.
That's right.
Yeah, that's where mediation is beneficial. Because those
Right.
discussions that take place in mediation that unfortunately don't have much of a place in the courtroom.
Yeah, I have a question to Christian. I could never figure out why you introduced this issue of the other problems with the neighbors.
Well, because there are always other problems.
Well, because that was a
There's always, and there's always other problems.
I'm sorry.
It's not just one.
Yeah, because I wanted to bring up other issues. You know, I wanted to take it to another place, which I see a lot of.
Yeah, I think sometimes parties will be trying to make a stronger case to the mediators as if the mediators are judges or arbitrators.
Right.
Right, right.
As a mediator, it was interesting for me to find out that the plaintiff has the burden of proof. As a mediator, can I tell the plaintiff that
If they go to court.
if you don't resolve this today, then you have the burden of proof before the magistrate?
I think you have to be careful giving legal advice.
Right.
Yeah. So I mean, I think just let them come to us with a blank slate. I think is probably the best policy, because you never want somebody coming back and say, well, the mediator told me this and I relied on that. That's why I'm doing it this way.
That's the most trouble we can get in, is acting like a lawyer.
Yeah.
If it's a bar association.
What?
Even if
I
we
do
are.
find that sometimes when we may not, well, I'm not going to say we, I'll say me, when I find out that they're not close, but it actually feels like they can resolve it, and one of them might say, well, I want to go before the judge, and I'll say to them, you have every right to go before the judge or the magistrate, but just keep in mind one person will win and one person will lose, and you will also miss another day's work. And then they're sitting, they think about that, and then, okay, and then they kind of work it out. Not all the time.
Oh, sorry. A bit of a counter argument to that. When I did the civil mediation training, one of the things we learned was to you have to sort of inform each side of the risks they take in going to trial, and so especially in larger civil mediation cases. So you need to, I mean, I'm an attorney, but then if you sort of have that responsibility to point out to them, here's the weakness in your case, here's the weakness in your defense. And so you are kind of, and you might, and oftentimes questions of law come up where you have to inform them, under this case, your case stinks, but, etc. But, and it's still not taking sides, you have to be equal with each other, but I think there are times when it's appropriate to give what's sort of legal advice.
I think that's evaluative mediation, like when there's a panel, like in a civil case, there's a panel, and then they do that. But with this sort of thing, I think you're
right.
stepping over.
Facilitate mediation.
You want to let them have a conversation.
Yeah.
I often will say to people, as a mediator, I would say, if both of you are a little unhappy with the deal we've worked out, it's probably a good deal. If we go to court, one of you is going to be really unhappy. So are you willing to be a little unhappy and settle this?
Or would you rather go
risk
before the
being
magistrate, have
really
the chance that
unhappy?
you're going to be the one who's really
Right,
unhappy?
and then they'll say, well, I have a great case, and then you say, well, both of you have some weaknesses in your case, and the judge is likely not going to see it exactly how you see it.
Yeah.
And then,
Keep it very generic.
right, and not a specific bullet point.
And just saying you have some weaknesses in your case, or you've brought me no evidence whatsoever, is that providing legal advice?
Well, so I would never say you brought me no evidence, but I would say, you know, both of you have some weaknesses, and a judge is going to evaluate who's credible, and they're going to look at your evidence, and they're going to listen to your testimony.
I often say, how would you feel if the judge decided that she was right? And how would you feel if the judge decided he was right? And if they both say, that's okay, I'd rather go to court, then I say, go for it. Yeah.
Sometimes I stop and check with the clerk to see what date they would be scheduling. And I use time as a leverage. I say, you know, you've been dealing with this for however long. And if you don't agree today, you know, they're scheduling for 6 weeks out, just so you know. And you carry it for that much more time. And so many people are so sick of it by the time we see it. It's like, oh, Lord, you know, another 2 months. Anyway, it's a little bit of leverage to encourage them to work really hard. So, I don't know. That's something I do.
Sometimes they think that they're just going to leave us and go to court.
Exactly.
Walk to the next door.
How it works.
Yeah.
So just procedurally, it just helps them think through what's going to happen.
Well, they come see me, they make, or see us, they make assumptions too. They say, okay, well, when do I come pick up my check? Not going to work that way, that's for sure. Anyway, and that's one of the risks of not coming to a mediated agreement or having an understanding amongst yourselves how it's going to resolve. So because now you're relying on collection processes, which are, you know, put more burden on the person trying to collect. You know, they have to go through these, jump through hoops to, you know, get information so you can execute the judgment, make your collections and things like that. Once you have the judgment, you're not even halfway home at that point. Whereas if they made a mediated agreement, chances are much greater that they're going to go ahead and follow through.
The state has done research and they found that's true, that they're more likely to follow through if it's decided in mediation than if it's decided by the court. And they're usually happier with the result. And we do a survey every 18 months to find out how many people who reach agreement do follow through, and it's quite high. Yeah.
Is that something worth pointing out to parties in a mediation? That
Actually, I do. If I will give a mediation talk if I get a group of people together at the same time, and that isn't always possible, so I don't always do it. But if I do it, I'll often say, use that. I'll say it. Yeah. I also will tell them about a magistrate I knew in Ohio who said, people come to me expecting justice, and I don't have time enough to listen to give them justice. And I said, what do you do? And he said, I make a decision for people who can't make a decision. And this is your chance to make a decision, like Craig said. It was shocking to me when I was working in the court for having magistrates say that so clearly. I can't give them justice. Oh, okay. Thank you all for coming, appreciate it. And if you all will fill out an evaluation form, and if you have an idea for next year, what you'd like for a brown bag lunch, be sure to jot it down and give me your name, or you can email me at any time with any suggestions. And thank you all so much.